5 seconds. Let us first examine the decision cited by the Land Council for the respondent SCC, the Punjab and Haryana High Court in the case of Max India Limited. Supra took the position that if the view expressed by the assessing officer was a possible view, the Commissioner of Income Tax would have no jurisdiction to interfere with such a view by exercising his powers under Section 263 of the said Act. The decision of the Punjab and Haryana High Court in the case of Max India Limited Supra was carried to the Supreme Court, and the view taken by the Punjab and Haryana High Court was confirmed in CIT versus Max India Limited ITR 295 ITR 282 SC. The Supreme Court also clarified its earlier decision in the case of Malabar Industrial Company Limited Supra, which has been strongly relied upon by the Land Council for the revenue, that the phrase prejudicial to the interest of the revenue in Section 263 had to be read in conjunction with the expression erroneous. The Supreme Court further clarified that every loss of revenue as a consequence of an order of the assessing officer cannot be treated as prejudicial to the interest of the revenue. As an example, the Supreme Court noted that when an income tax officer adopts one of the courses permissible in law and it results in loss of revenue, then it cannot be treated as an erroneous order prejudicial to the interest of revenue. Furthermore, where two views are possible and the income tax officer has taken one view with which the Commissioner of Income Tax does not agree, it cannot once again be treated as an erroneous order prejudicial to the interest of the revenue unless, of course, the view taken by the income tax officer is unsustainable in law. The Supreme Court in the case of Max India Limited Supra also noted with reference to Section 80 HC that the said provision has been amended 11 times and that the mechanics of the section have become too complicated over the years, that two views were inherently possible, and therefore the subsequent amendment in 2005, even though it was retrospected, would not attract the provisions of Section 263, particularly because it is the position of law as it stood on the date when the Commissioner passed the order under Section 263, which is be taken into account in testing whether the Commissioner of Income Tax correctly exercised his power under Section 263 of this Act. Hari Iron Trading Company Supra was another case which was decided by the Punjab and Haryana High Court. In this decision, the Punjab and Haryana High Court took the view that the Commissioner of Income Tax, while exercising his power under Section 263, has to look into not only the assessment order but the entire record of the proceedings before arriving at a conclusion as to whether the assessing officer had examined any issue or not. This is so because the SSC has no control over the way the assessment order is drafted. It was further observed that during the course of assessment proceedings, the assessing officer examines numerous issues, and generally the issues which are accepted do not find mention in the assessment order, and only such points are taken note on which the SSC's explanations are rejected and additions disallowance are made. The said High Court's observations to this effect were as under